Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all. So I say if we get rid of all of our troubles in the first hour, everything should go smoothly. So I thank you all for your patience. It seems that whatever could go off did, and but we're ready to start. What was I going to say? Before I call on you, Mr. Schachter, I just want to acknowledge that before court this morning, we had 2 ceremonies, and the result of one is that the Eagle staff is currently present in the courtroom, as are the wampum belts. Is there anything else we need to touch before you start?
I just don't know if the court wants appearances from all counsel and to start.
Why don't we go ahead?
My name is Harley Schachter. I appear with Caitlin Lewis, and we represent White Sand and Red Rock First Nations, and through a representative order and with the consent of 3 First Nations, White Sand and Red Rock represent the Treaty First Nations of Fort William, Gull Bay, and Michipicoten as well.
Thank you.
Good morning. I'm Brian Gover. I appear with my colleague Spencer Bass on behalf of the First Nations that have come to be known as the Group of 7 First Nations.
I'm Glynis Evans. I represent the Attorney General of Canada, along with my colleagues, Mr. Cameron Fisk, Ms. Claudia Sang, and in the back row, we have Ms. Isabel Crew and Ms. Rhiannon McNamara.
Morning, Your Honor. I represent the province of Ontario. My name is Len Marcello. Up front with me today are Tamara Barkley and David Rankin.
Thank you.
Good morning, Justice Hennessy. We'll resume. This is Jeremy Greenberg for Nanakuzuzigagan. We had a party like this.
Thank you.
Okay. So we're going to start with the closing submissions of the plaintiffs, and I'm leading off. I do not know how many days I will take. I may finish on Thursday, but we'll see how time goes. First point I wanted to make is that I wanted to acknowledge the kindness with which we all have been received by the Anishinaabe of this land. And I think a special thank you from me personally, and perhaps on our team, and I probably can extend it from all council, is a special thank you warranted to the Fort William First Nation, who have so kindly welcomed us, all of us, no matter which side of the litigation we have been on. We have been invited to and enjoyed, those that could attend, ceremonies and feasts over the last few days. So I wanted to take a moment to thank and acknowledge that. The next thing I wanted to mention is that I will be providing the court with my argument, but when the lawyers for the Group of 7 stand up, I do intend on relying on their submissions, and we have tried to coordinate our submissions so that we do not repeat each other over and over again. And so hopefully you will get the benefit of the best argument on major issues from the parties. Next, I wanted to just take a moment to hand up a compendium and to hand up a outline, which I'm going to speak to shortly. So what the oral closing submission compendium is, it's a list of documents that I think are going to help guide my submissions. And included, in addition to the compendium, I've handed up an outline, which I'm going to get to after I finish some opening remarks. But what the court should have in front of it, in addition to the compendium, is the written submissions of all the parties and the interveners, both in the main argument and in reply. So my plan is to make a few opening remarks, and then I plan to list for the court's consideration a roadmap or an outline of the areas that I'm planning on talking about. And I think as we go along, the court will observe that it's not my intention that we simply repeat verbatim our written submissions in either main or in reply. We do still rely on them, and we have every confidence that the court will be reviewing them and has reviewed them. But we want to focus our energies in this week on the issues that from our perspective deserve some emphasis. Now, as I proceed, I am expecting questions from the bench on any subject the court wants to discuss and wants answers on. And so I would ask the court and encourage the court to ask any questions it wishes as and when a question arises. At the end of the week, I want to ensure that the court has got my client's position on each issue of importance. So with that, I want to make sure the court has my submissions, our new compendium, the arguments of all parties, and it would probably be useful if you to have handy the reasons of this court in phases 1 and perhaps 2, the reasons of the Court of Appeal, and of course a copy of the outstanding amended judgment from phase 1. I would ask the court's direction. Does the court want to mark the compendium as a lettered exhibit?
I would like to mark it in some way. Is there any, do we need to go through the lettered and then numbered exhibit? Or I suppose it's just a lettered exhibit.
It should just be a lettered exhibit. There are some documents in there that are not in exhibits in the trial, and sort of like aids to the court. So I'm not sure what number or letter we are up to.
I am told it's I.
Aye, gotcha.
Mr. Schachter, perhaps you have, but could you consider when you want to break? It's 11:15 now and you're just starting.
Right. So what is the court's preference? Does the court still want to break at around 12:30?
For the lunch hour?
Yeah. What is the
Well, I would say between 12:30 and 1. And so would you go straight through, or do you want to?
I would be quite happy to go straight through,
All right.
but I don't think I need a break yet.
All right. So why don't you look at where you are at 12:30 and see if you want to go later than that?
All right, perfect. So I want to start with some opening comments. On January 30th, 2023, I stood before this court in Sudbury and delivered an opening statement. In that opening statement, my opening words were that the Crowns have a very different vision of the path to reconciliation than the plaintiffs do. At that time, before the phase 3 evidence on experts was tendered, and based on what we read in the Crown's experts' reports, We observed at the time that notwithstanding the 2018 decision and judgment, notwithstanding the 2021 amended judgment fixed by the Court of Appeal, the Crown's vision of implementing the sharing agreement found to exist by the treaty left little room to consider the interests, wants, aspirations of the Anishinaabe. The court might recall that we likened the Crown's approach to a fox seeking the approval from the court to remain fully in charge of the chicken coop, and the future looked pretty dim for the chickens. Well, the court and the parties now have the benefit of the evidence of stage 3. The plaintiffs say that a fair consideration of that evidence, including the plaintiff's evidence from elders and chiefs, and including a consideration of an appropriate weight to be given to the testimony of the various experts, when coupled with common sense, application of the law, and a fair interpretation of the outstanding stage 1 amended judgment, supports the plaintiff's case and refutes the case that the defendants have brought. I want to return to some words from the Court of Appeal, because I think they resonate into and demonstrate perhaps a great difference between the two sides on this case. And that's paragraph 323 of the Court of Appeal decision. At paragraph 323, the Court of Appeal quoted from this court and said, "The trial judge noted the court and the parties must return to the shared goals, expectations, and understandings of the parties in 1850, and based on those shared goals, expectations, and understandings, devise processes and procedures for the implementation of the treaty's promise in the modern era. The parties," and the Court of Appeal continued, "the parties in negotiations or the trial judge in stage 3 must determine the form, level, and aim of the sharing that the augmentation clause requires. The parties and the court should be led in doing so by the treaty parties' shared goals, expectations, and understandings in 1850, including the Anishinaabe principles of respect, responsibility, reciprocity, and renewal identified by the trial judge, and the Crown's commitment to being both liberal and just." Now, notably absent from the Crown's implementation principles are an acceptance that the Court of Appeal was clear that absent agreement among the parties, it is the responsibility of the trial judge in stage 3 to determine the form, level, and aim of sharing. For the Crowns, it is they and not the court who have the discretion to determine the form, level, and aim of sharing. Respectfully, this is contrary to the express wording of the amended judgment at paragraph 3A. It is for the court to determine the amount of net revenues by the terms of the treaty. Moreover, this is precisely the role that courts in our democracy are intended to fulfill. It is the courts and not the Crown who are the guardians of the Constitution. It is the courts that protect the rights enshrined in the Constitution, and it is the court's role and the courts to whom the citizens properly look to for vindication of their rights. The Crown's approach ignores that the Court of Appeal confirmed that the graciousness clause does not apply to the collective annuity entitlement. It only applies to the amount to be distributed to individuals. Canada, at paragraph 48 of its argument, bases its argument on the idea that the graciousness clause and the discretion afforded thereby applies to the determination of the amount of the annuity augmentation. Respectfully, this is wrong. Ontario is a little more subtle, but they arrive at the same conclusion when they posit at their written submissions at 465 that any remedy must preserve the Crown's discretion regarding the form and level of sharing. And they ask the court to refrain from issuing a monetary award at all. Well, it appears to the plaintiffs as though the Crown's approach is almost as though phases 1 and 2 did not happen. This is alarming. It remains troublesome. The chickens remain very much afraid. Consider the bleak outlook that Ontario's experts arrived at. Their vision is an implementation. This is not only their experts, but the one that they propose the court adopt, is a sharing arrangement whereby the future opportunities and future potential of the treaty territory, those are the words taken from paragraph 2B of the judgment, can be fulfilled by a sharing arrangement that reduces to 50% by 1877 and to less than 1% in 2019, with the share forever reducing each year below 1% forever. That is not an interpretation that facilitates a continuing, mutually respectful and beneficial relationship going into the future. Those are the words of paragraph 2A of the judgment. Those are not the words of an implementation that is honorable and is just and is in keeping with the facts of this case. True, Professor Smart did claim that after adopting it's down to 1%, the parties could renegotiate the percentages for the future. But here again, common sense intervenes and renders that proposition unlikely to be of any solace to the Anishinaabe and should be of no comfort to the court. What possible incentive would there be for the Crown to renegotiate a bargain set by the court that requires the Crown to pay less than 1% forever into the future? There is no basis in Crown conduct in the past to suggest that it is even a remote possibility of a negotiation process that would yield a result consistent with the honor of the Crown or the spirit and intent of the treaty to share and provide for both the Crown and the Anishinaabe. Absent as well from the Crown's vision of honorable implementation is any consideration of the Anishinaabe principles of respect, responsibility, renewal, reciprocity, kinship, Bamadzuin. Absent are considerations of justice, fairness, liberality, and benevolence. Now, although it's really at the outset of my submissions, for all the reasons set out in our written submissions, and after the court considers all that we have to say and hears from all counsel over the next few weeks, we are asking the court to firmly reject the Crown's vision of the Robinson Superior Treaty and to conclude that the vision put forward by the plaintiffs is fair and just and appropriate. We are asking the court to fashion a just award that is built upon a solid foundation that is laid in the evidence by Professor Stiglitz, Mr. Hutchings, and the other plaintiffs' experts, Dr. Dribbin and Dr. Bignami. Their approach is sound, just, and fair, and follows the facts and history. Those facts include the testimony of the plaintiffs' lay witnesses, chiefs and elders, and counselors who with utmost grace and heartfelt emotion eloquently explained Anishinaabe perspectives on kinship, respect, responsibility, renewal, reciprocity, sharing, and Mino Bamadzuin. the good life. You know, I was in the communities of White Sand and Red Rock this past week. I have been welcomed into those communities for many years now, and I could see on the faces of many the great anticipation that a final judgment was close at hand. And yet being in those communities, I have to tell you, was a little bit difficult for me, because not because of the faces I saw, but because of the faces I didn't see. I didn't see the people who have passed away, who I have come to know and respect. I didn't see them and wasn't able, notwithstanding my efforts, to give them what they deserved, some measure of closure as speedily as possible. They passed on without seeing the improvement in their lives that a proper implementation of this treaty was intended to bring about in 1850. And for that, I'm sorry that I could not fulfill that for those people, but that just tells me the importance of a final and binding decision now. A declaration, a mere declaration, which is what Ontario asks for, with an invitation to engage in a process to discuss levels of compensation based on guidance from the court, would not be fair and just in this situation. What is required in this case at this time is a final decision on past compensation and a clear direction from the court on how future augmentations are to be calculated. Now, such a result would still permit renewal of the treaty relationship by agreement. But that discussion, that negotiation must take place as a discussion among equals. And in order for it to be a just and fair negotiation, it cannot be achieved if one side to the negotiation holds all the power. To suggest, as I think my friends will, Ontario and Canada, that the Crown's power is already burdened by the honor of the Crown, respectfully, is not a sufficient answer here. I want to remind the court of some historical incidents, historical facts. I don't need to go into the evidence books for this. I don't think anyone will doubt this, but in 1763, the Royal Proclamation assured protection to the Anishinaabe, and we know that that faltered. In 1849, Vidal and Anderson spoke eloquently in their report for the need for a just and equitable treatment of the Anishinaabe. In 1850, Robinson spoke of the prospective benefits so reasonable and just that he had no difficulty in making the Anishinaabe comprehend it. In 1858, no less than the Commissioner of Crown Lands, Carney, wrote to Pennyfather suggesting it would be an injustice to give away lands to the prejudice of the Anishinaabe. And that, yes, the Crown could give away its lands, but in determining what to pay by way of augmented annuity, what made sense to Carney was that the full fair market value should be taken into account. We have the evidence, and the court has heard about, from the 1850s to the 1890s, the Anishinaabe pleading and sending petitions seeking fulfillment of the treaty. All of those, save for the events of 1873, seem to have fallen on deaf ears. In 1895, the Supreme Court of Canada reminded all about the honor of the Crown And that was in the re-annuities case. My clients were not present at that 1895 case. Ontario and Canada were. And one of the justices made clear that the honor of the crown applies. In 2004 in Haida, and in 2005 in Mikisew, and in 2013 in MMF, the Supreme Court of Canada again reminded the Crown of the importance of the honor of the Crown. In 2018, this court did the same. In 2021, the Court of Appeal did the same. And yet, the Crown has not engaged in any process with the Anishinaabe. And throughout it all, Ontario still holds to an interpretation of the treaty whereby the Crown need only advert from time to time to whether Her Majesty would be graciously pleased to increase the collective annuity. But even that vision remains a distant thought. Ontario, you might recall, advocated for an increase based on cost of living that would see, from their view, as each person might get $126, I think it was back in 2018. Yet nothing has transpired there. There hasn't been any interim payments. There hasn't been any engagement process. Respectfully, as much as I, like many people in the field, had great hopes for the honor of the Crown when it was rediscovered in 2004 by the Supreme Court of Canada, it is just 5 words. It is 5 words that do not effect results without a decisive court award that has meaning and teeth. There is nothing in the Crown submissions before you today that should give the court any comfort at all that the Crowns are prepared to engage in the near future with honor. Now, before concluding my opening remarks, I want to leave the court with a few charts that summarize Stiglitz and Hutchings' calculations as compared to Ontario's experts, Bodway and Smart, at various bring forward rates. And I want to identify where the evidence comes from. So if you wouldn't mind looking at tab 4. At tab 4 of the compendium, starting at page 14 of the compendium, I have 5 sheets. The first one is nominal resource rents. And what I've done is I have tried to collect the summary of the evidence on numbers with reference to where the court can find it in the evidentiary record. And I've presented the numbers in nominal amounts and in bring forward amounts. So for example, at page 14, I've identified where on resource rents, Stiglitz and Hutchings identify the nominal value of 3.951 billion. The Crown expenses in the next column that are properly deductible, and it explains how Stiglitz and Hutchings get to their net nominal resource rents to 2019 at 3.586 billion. And that's without it being brought forward. The next page, page 15, is nominal resource-based revenues actually captured by the Crown. And on this chart, I've got both direct and indirect. And I want to make, and I've got the positions of all the experts that I could see who opined on this. And the direct gross is 1.336 billion. And there's the familiar number that was talked about a lot at column C, the net nominal direct NCRRs to 2019, 1.043 billion. And you can see the comparisons from Smart and Bodway, where Smart and Bodway actually arrive at a negative $1.616 billion.
But I just have a moment to annotate this.
Yeah,
So I'm at your, I'm trying to, I'd like to annotate the A, B, C, D, E. Oh, you've got it on a side column. Okay, I've
Yeah.
got it.
okay. And look, the reason I'm giving this to you is so that you have a ready place to go to sort of, if you do want to see where did this number come from, where is it in the evidence, this is where it's at. There is one number that sort of jumped out at me that I thought, well, does that make sense? And that's, let's look at page 15, column B, and supporting expenses to be deducted.
Yes,
You'll see that it's 0.293 billion.
yes.
And you might recall that there was a fair bit of evidence from Mr. Hutchings that he used a rate of 31.9% on as an expense ratio
Yes,
for post 1945. And when you do the math, the 0.293 is over 1.336. Well, that's only 21.9%. Why is there a discrepancy? The answer is, of course, because hydro is only an expense ratio of 2%, and spectrum is much less as well. So the 0.293 includes in not just lands, minerals, and forestry, to which the ratio is 31.9% on average between 1898 and 1945. That was the evidence there. It also includes in a very low expense ratio for hydro, which, as you remember, was agreed to by Ontario's expert, Mr. Hamal, and also low supporting expenses on spectrum as well, which was agreed to by all parties. So don't be confused by the percentage difference.
so can you just help me then, that 0.293, we would have seen it if absent hydro and spectrum, we would have seen that number as what?
It would be get closer to, well, it would get closer to 31.9%. It would get closer to, and I say closer to because remember the 31.9% post 1945 ratio was not in respect of the period 1850 to 1945. Mr. Hutchings said because the data from the Irving papers was not reliable for that purpose, he took actual data from 1898 to 1945 to come up with the 31.9% average.
Right. The question I was asking was, what's the number that we would have seen before if we were looking at Stiglitz and Hutchings expenses? It wasn't 2.293 doesn't ring a bell, or do I have that right?
No, it doesn't ring a bell because it hasn't been presented before.
Right, but
Right.
what was the number present? What's the number?
The number presented was 1.043 billion in column C, right? So that's the number that was before the court. I believe the gross direct NCRRs was also before the court. But the focus was Mr. Hutchings saying, I've done my calculations, court. The net nominal direct NCRRs to 2019 is 1.043. And the court might recall it went down from a couple $1 million with some changes he made.
Are you saying that we did not hear in evidence a number for, from Mr. Hutchings on supporting expenses?
That's correct. It's in his work papers, but we
He only,
didn't.
he only gave us the percentage.
No, what he did is he gave us the gross of 1.336
Yes.
and he gave us the net and he said that was his calculation. And what I've done in this chart is I've actually said, well, how do you get from gross to net? And I have gone into the work papers and you'll see this, the same issue for Smart and Bodway. You'll see that their work papers is, you have to go into their work papers and actually figure out how they get to 1.616 billion. And you remember, they never mentioned 1.16 billion. They mentioned minus 4.3 or 4.5 billion because they always used not nominals. They used brought forward at bond rates. And so I'm trying to provide the court with an apples to apples comparison. Part of the problem through the trial is that Ontario's expert would bring it forward at bond rates and say it's negative 4.5 billion, but he wouldn't bring them forward necessarily at 60-40 rates. And so what I tried to do is go through the evidence and the work papers to identify where everyone came up with their figures.
Thank you.
At tab 16, oh, sorry, I want to back up to stay on 15 for a moment. You might recall that the plaintiff's case is that what is to be, the treaty says is to be shared is not just the direct revenues from that Crown receives related to resource-related revenues that it captures directly, but also the revenues from resource rents that it indirectly captures. And we heard evidence about that being 25 to 35% from Stiglitz and Hutchings, and we didn't hear evidence from anyone else on what that percentage was. And I'll talk a little bit more about that in my presentation, but the math turns out to be $0.763 billion nominally. And if you add up the direct and indirect amounts, you get 1.806. And the court I will end up at the end of my talk, the end of my submissions with my relief requested page, which is my, was it Schedule A? Appendix A to my written submissions that has these ending numbers in them. So I wanted the court to know how I ended up with that. I didn't just pull them out from the air. I actually went into the work papers to figure it out. So, yeah, sure.
I have a question now that may make more sense when you get into the guts of the economic evidence, but the indirect revenue, indirectly captured revenue.
Yes.
Throughout these submissions and throughout the evidence, it is often followed by the words in parentheses, taxes, some kind of taxes, either
Yes.
Income taxes, personal or corporate. Was there ever any evidence on what indirectly captured revenues were other than taxes?
No, I don't recall that there was. I think it is indirectly captured through taxes, but at least that was the evidence was. I recall one of the articles written by, I think it was Mr. Bodway, that talks about the indirect capture being through the corporate income tax.
Right. And so can we use those interchangeably? The indirectly captured revenues and taxes? Am I understanding it correctly, and would I be saying it correctly?
Well, you raise a good question that I'm going, before I say yes, I think I want to actually make sure that my answer is correct. Because it might be there's other intangibles that I haven't thought about, but I don't recall there being express identification of what they were other than taxes.
Other examples?
Yes, but I'm going to, I don't have the, I wish I had a photographic memory of everything I read, but I don't. So I'm going to have to put that on a list to try and answer that question more thoroughly later, and it's a good one.
I did check a couple of places and I didn't see it.
Yeah.
So I'm giving it to you.
Yeah, I didn't see it either, but if I do, I'll most certainly let you know.
Thank you.
I will say, though, that the fact that it's taxes doesn't trouble me at all. I mean, the fact that it's taxes, I mean, I guess in retrospect, the fact that the Ontario Court of Appeal said to be cautious, we should take out the reference to no taxes count. In retrospect, that was a good thing, because really what we're seeing is really what is value of the resources is being recaptured through taxes, right?
Well, and if I I can understand taxes. I can't understand what other possible examples are.
Yeah.
So that's where.
I don't have any for you now, but we're going to check.
So then my next question is,
Yes.
and maybe you've already said this. In order to calculate 25 to 35%, or let's say 30%.
Yes.
You applied that 30% against all rents, all resource rents. Is that correct?
Yeah, what you do is you actually you take all of the value of the resource rents, and let's use numbers to sort of make it clear. The net nominal resource rents to 2019 were 3.586 billion. And so what you would do is you would say, okay, well, if the resource rents in total, if the total possible world of the benefits that come from resource rents is 3.586 billion, and we know that the Crown directly captured 1.043 of that, right? Because we know that the difference, if you take 30% of that difference, that's how you arrive at 0.763.
It's 30% of the difference, not
Yeah.
30% of the 3.586.
That's correct. It's 30% of the difference. And somewhere in my written submissions, I've tried to make that clear, and we'll find that for you, and we will alert you to that when we find it. At page 16, we have the nominal and present value of the net resource rents. Now, of course, notwithstanding that Stiglitz and Hutchings report was provided, I guess, close to a year before the trial started. The idea of, and that's where the idea of resource rents was floated. Minson, Ryden, and Smart and Bodway did not calculate resource rents. And so Stiglitz and Hutchings, their opinion was that the nominal resource rents were 3.586. And if you look at the long-term bond rates, the band trust account rates, and 60/40, this is where you get the 60/40, which ends up being an approximate 7.2% annual rate of return over the years. This is where you get the 126.285 billion that the plaintiffs submit forms an appropriate award. At page 17, you have a similar calculation for nominal and present value of net Crown resource nominal and present value of net Crown resource revenues, the direct only. And there you see again, Stiglitz and Hutchings 1 point. Well, I wonder if I've just made a mistake. Yeah, I did. I apologize. On page 17, Stiglitz and Hutchings, nominal, I put in the gross by accident. It should be 1.043
Okay, where are you?
on page 17.
On page 17,
Yeah,
the column nominal direct.
yeah, those are the nominal directs are wrong. I accidentally put in the gross number.
Okay, let's. Whoops.
So it's not 1.336 in the second column under nominal direct NCRRs to 2019.
So it's the figure footnote 13 should be 1.043.
Yeah, not 1.336.
I'll change that now.
Yeah, thank you. I apologize. And then what we have is how that translates into present day terms for up to 2020 at 5%, at bond rate of 5%, at the band trust account rate of 5.3%, and at the 7.2% blended rate. That's how we got to the 56.895. Yes, my friend has also pointed out that the Smart and Bodway number is also incorrect. And I'm not exactly sure what the nominal directs should be a negative number, of course, and the negative number nominally we can find from, excuse me, the same chart on page 15. It's negative 1.616 billion. I just transposed the wrong column is what I did.
Negative 1.616.
Yes, it's the exact same number on page 15 of the compendium tab. Tab 4, page 15, third column at the bottom, Smart and Bodway 1.616 is the net nominal directs. And I had put in the gross again. I just, in the column on page 17 where I say nominal direct NCRRs, I accidentally put in the gross instead of the net. I'm glad I caught that now. In answer to the question of how do you get to the 0.763, the court will find that explained at page 33, paragraph 371 at page 80 of our main argument. I don't plan on going there right now, but if that's okay.
Thank you.
And the final list of figures at page 18 is the nominal and present value of the net resource-based revenues actually captured by the Crown, both direct and indirect, and how you get to the numbers of 77.712 billion simply on the basis of what the Crown actually did collect directly and indirectly. So it starts off with nominals of 1.806, And at 5%, you get to 14 billion, 14.581 billion. At band trust account rates, you get to 15.697 billion. And at 7.2% at 60/40 rates, you get to 77.712 billion.
So I'm just going to give something back to you if I can.
Yeah,
So the 1.806 represents the directly captured revenues and 30% of the difference between the resource rents
yes,
and the directly captured revenues.
you got it correctly. That's right. And what the page 18 really tells us is, if you want to answer the question, what did the Crowns actually get from the resource rents? It's this number, 77.712 billion over the years at the bring forward rate, 1.806 nominally. But you have that right. And so that is the number in our analysis that we say the treaty says we're supposed to share in what a portion of what the Crown gets. Well, the Crown got 1.806. We're supposed to share in that.
And the debate then between the experts or between the parties is firstly how, if at all, to calculate total rents, resource rents. And then there's a secondary challenge to the 30% number. Sorry, how to calculate the total rents,
Well,
whether taxes should be considered as a portion of what the Crown has collected, and then a less significant debate or challenge to the 30% number.
that's correct. I think that's fair. But keep in mind that we do have when we talk about the calculation of the resource rents,
Yes.
those are the world of value from the resources that are there to be captured by the Crown directly and indirectly.
Yes.
And in the analysis of doing of the work to see what did the Crown capture directly, the plaintiffs and the defendants were actually very, very close, right? If you look at page 15.
Yes. There's not a big debate about that.
Right. So where the debate is really not so much on what was collected. And the method, I would put it this way. Stiglitz and Hutchings and Smart and Bodway both analyzed what was collected directly and came up with numbers that were very close. Stiglitz and Hutchings went the further step of saying, well, how much were the resource rents, which is a step that Smart and Bodway critiqued, but they didn't do.
But one of their criticisms were how to calculate it.
Right. Yes, I think they had that criticism, but they said it could be done, but they didn't come up with their own methodology.
And a criticism on the concept of doing it at all.
Well, their criticism on the concept was really one driven, I think, by their instructions and by their reading of what the treaty bargain was. And here, maybe I can just get to this right at the outset. I think there's a fundamental point here that I'm not sure if the Ontario's experts appreciate it. I want to make sure the court appreciates. It's that we are not saying that there's some that the treaty bargain says that we must share in all, that the Crown must share all the resource rents. What we are saying is that the Crown must share what it gets from the resource rents. But, and I'm going to get into this maybe a little bit more detail, but I'll say it right now. The loss caused by the breach of treaty is different than the treaty right itself, right? The treaty right is to share in the, share a share of what the Crown extracted, what they captured. But the plaintiff's loss is not restricted to that, because what the plaintiff's loss is not just that share. They lost the opportunity to engage in a process by which that pie, if you will, would have been greater.
And the debate on that is, would have or could have been greater. It's
Yes.
unpredictable what it might have been had they engaged. Is that fair?
Well, Ontario and Canada would argue that there, and indeed have argued that there's no direct evidence that they haven't proven on the balance of probabilities that it would have been different.
Right.
But we're going to get to that about why that's not our onus and
Okay.
and why.
I wasn't putting the onus to you.
Yeah.
I framed it as that's the debate.
Yes, yes, undoubtedly, yes.
So if we just go back to that first proposition that you say the treaty right is to share in what the Crown did extract, which you say are the direct plus the.
Well, no. The treaty, I'll try and rephrase it. The treaty right is twofold. It's to engage in a process to define what the revenue, the net Crown resource-based revenues are to be. So you engage in that process, and perhaps you have a discussion and someone says, but Mr. Carney, you're giving away land. And Canada and Mr. Carney responds, well, that would be unfair and unjust. I think what we should do is we'll give it away, but in our accounting with you, in our figuring out what the net Crown resource revenues are for the purpose of sharing, we will impute a value to what we are giving away. So that opportunity represents the lost opportunity part of our case. But we recognize that after that engagement process takes place, and after determinations are made, and if they are not challenged, well, then the treaty right is to share in what, or the remaining part of the treaty right, excuse me, is to share in what the Crown did receive. But our case is built on two things, really. It's, we are entitled to, in retrospect, because the treaty was not honored, because it was breached, because there was no engagement process. Our loss is comprised of not only what the Crown did extract, which is 77.712 billion, but it's also a loss over and above that of what might or could have happened. Well, I guess could have happened if equitable presumptions apply, and could have and likely would have happened based on loss of chance in contract law. And applying those contractual principles, I'm going to suggest to you, actually ends up at the same place as equity, because of the principle that I talked about in my argument of the reason why the principle of highest and best use applies is not because of equity, it's because of consequences to a wrongdoer of withholding information, not being able to identify and not being able to say to the court or have the court accept that things would have been the same anyways. And I think I made a reference in my argument somewhere to Donovan Waters and on trusts and the case of Armory and Delamere, which I think is from 1722 or something, if memory serves me correct. I know I'm old, but I wasn't there. I wasn't watching, but back when I went to law school, it was that case, Carbolic Smokeball. And
Even I wasn't there.
yeah. and maybe Donahue and Stevenson, they were, these were the cases that young lawyers learned about. And Armory and Delamere, of course, the case of conversion, a tort, not equity. The jewel thief, who, not a jewel thief, excuse me. The jewel thief was the bailee, a bailor, the person that took in the diamond. Anyways, the guy takes in the diamond and the diamond goes missing, and the finder of the diamond says, "Where's my diamond?" And it goes to court, and the court says, I think I'm paraphrasing, but the court says, we have no information as to what the diamond's worth. We don't know, because it's the fault of the person who stole the diamond that we don't have the diamond in front of us. We can't know. Court says, you got to presume it's a diamond of the best water, is the expression they used in the case, if I recall. So the best possible diamond that it could possibly be, and that's a common law presumption, not an equitable presumption. I mean, equity kind of follows the law in that regard. And so even at common law, we say we can, at the end of the day, we can rely on that common law presumption. But I guess I'm also going to let you know throughout my argument that we actually don't have to rely on that, because we say that based on the evidence, it is likely that there would have been an increase beyond 77.712, because a crown, cognizant of its obligations to diligently and purposefully implement a treaty by which parties are to both benefit, share, and succeed and thrive, and to which the honor of the crown applies, would not have sat silently and said, yeah, sorry, we're not going to do anything about that. That's not likely what would have happened in 1858. And we know it wouldn't likely happen, because had they sat down with Mr. Carney in 1858 and had Mr. Carney worn the mantle of the honor of the crown and diligent and purposeful fulfillment, the court can conclude that a likely outcome of that discussion probably would have followed what Mr. Carney was suggesting. And what Mr. Carney was suggesting is almost identically to what, happily for me, Professor Stiglitz identified. And that is that the full amount of the rents could be captured, and in a perfect world would be captured by the owner of the resource, the crown. So the purpose, again, of me giving you these charts, and I'm glad that I was able to correct the errors I made in the charts, was to ensure that it will be useful for all parties, and especially the court, and that after submissions are done, Your Honor will be left with the task to arrive at a just figure. And it's my intent that you have all the tools that you need and the facts before you, and in a readily available way concerning this very important case, to allow you to make a final and binding decision so that this case can be concluded, and so that my clients can find some closure to this case. And on that score, I want to just say a moment about the timing of the decision we are asking for.
Oh, thank you. I do want to hear you on this.
The timing of the decision should not await the Supreme Court of Canada decision. The existence of an appeal to the Supreme Court of Canada should not factor into the timing of the release of your decision for a couple of reasons. First of all, Canada never appealed that decision. It's happy with your stage 1 decision. Secondly, Ontario sought a stay and in the Supreme Court of Canada and an adjournment before you, and that was rejected both by you and by the Supreme Court of Canada, who said the judge is in a better position to know if it should be stayed. Now, I know of no basis to suggest that this court or the Court of Appeal were wrong. Supreme Court of Canada often hears cases not because it thinks something was wrong with the lower courts, because it maybe wants to emphasize that the lower courts got it right, and they want to make sure that it's an important principle. We say that the presumption of regularity applies, and that the court, this court, should render its decision when this court is ready to do so, and need not wait for the Supreme Court of Canada to pronounce on stages 1 and 2. And I believe my friends from the Group of 7 are going to have more to say on this point, but I will leave that to them. But that's my position. So that, unless there's any questions about my opening remarks, that actually is my opening remarks. It's 12:15, and I think I can usefully go through my outline. Now, you should have before you an outline, a one-pager, and I wanted to just alert the court where I was planning to go. Now, the court at any time can take me off this agenda, this outline, this agenda as you wish. But I wanted to open with some errata. That's at item number 2. I've already done the opening comments and summary of the data. There's a little bit of errata. Then I wanted to talk about recollecting some historic facts. Fourthly, I wanted to talk about an overview of the credibility, reliability, demeanor, and helpfulness of each of the witnesses. Because as with any case with people who testify, the court's going to have to make some decisions about credibility and reliability, about who can be trusted, whether their opinions make sense and such. I want to talk then about the treaty promise is not the loss caused by the treaty breach. I've already introduced that subject, the difference between the two. I have I think a relatively important section, considerations to take into account in fashioning a just award. And here I'm going to be talking about why equitable principles matter and what principles should the court be looking at in fashioning a just award. I want to take a moment next after that to unpack causation and the proper approach to the could have and would have problem. It's actually not a problem. I think Canada, in my view, Canada may have misstated it a bit. But I want to see if I can, and Ontario didn't quite articulate it properly in my view, but we'll get to that. I want to then talk about some of the defendant's theories that I say are inconsistent with the reasons in the outstanding judgment. I then want to turn to the role for resource rents. After that, I'm going to get into the direct net Crown resource revenues. And I want to discuss 6 main topics there. And this is just my view of the, what I think deserves some mention, and that's general areas of agreement and disagreement on expenses and the plaintiff's conservative elements. I want to revisit and remind the court of Hutchings' approach to identifying relevant expenses. And of course, that the first and foremost is the matching exercise, that you match relevant expenses to relevant revenues, not to resource rents. I want to talk about forestry expenses, then logging taxes, and post-1945 expenses, and explain why Hutchings' 31.9% expense ratio is fair and reasonable and appropriate. And finally, under direct NCRRs, I wanted to talk about why transportation should be excluded and spectrum should be included. After I deal with NCRRs, net crown resource revenues, I wanted to talk about relative wealth and needs, and then turn to what the compound interest rates are, how to bring forward past amounts. 13, I would deal with the Anishinaabe share, and here you might recall that we had talked about Professor Stiglitz had talked about 84-16% sharing. That's where we're going to talk about that. Then we're going to get into a discussion that is actually primarily going to be focused, I think, about on a recent case called Yahi from the British Columbia courts. That is almost a primer on treaty obligations, treaty breach, treaty infringement, and the need for justification. And that is an important part of the case as well, I believe, because we say there has been a treaty breach. This is not a case of Section 35 consultation. It's about treaty breach, and the Crowns have not justified that infringement. I'll briefly talk about Canada's proposed holdback. I will then move to Crown liability. Obviously, in my written submissions, I make the point that the Crowns should be jointly and severally liable. And then I'll proceed with some concluding remarks with the losses flowing from the breach, to whom the award should be paid. Going to discuss some future implementation issues and end with the relief requested. All the while throughout this, being ready to answer the court's questions as best I can as we go along. So I still do have time. It's only 12:20. I'll go till 12. Maybe if I just finish the section on errata. At tab 1, I have 2 errata sheets, one for my main submissions and one from our reply submissions. And of them, they're mostly typos and grammar and fixing some citation. I don't know that I need to take you to them, except for 3 points that I consider of errata that I consider to be more substantive corrections. So if you could go to page 5 of the compendium, these are corrections having to do with the main argument. At item number 7.
So tab 1.
Yes, tab 1, page 5, item number 7. At page 71, at footnote 209, we had a reference that wasn't a proper reference to Mintz or Ryden's testimony. And it's important that I don't want the court to look at the paragraph 71 and say, oh, it doesn't say that at all. So we've provided the proper references at item number 7. So footnote 209 of the main report should be corrected. And the second thing of substance in the errata is that items 9 and 10. In Mr. Hutchings' main reports, he used the expense ratio of 31.4%, but that was overtaken by events and was adjusted to 31.9%. And I believe in our submissions, we had erroneously in the main report left it at 31.4. So that's kind of substantive. And the third thing, if you turn to page 7 on our errata sheet, you'll see that I've already corrected one errata of the errata sheet. How ironic, yes. Indeed, for those that can't see the document in front of them, on the hard copy, not on the electronic copy, I corrected it on the electronic copy. I had put in a wrong page on my errata sheet. So in any event, the first two items, 1 and 2, at page 4 of para 20, I had cited Canada argument paragraph 9. It should have been paragraph 24. And at page 4, at footnote 4, I make the following, ask for the following insertion to be included. Although Canada, paragraph 24 of their argument, do not use the words happy, that is what is inferred from the context of their argument. And I think I perhaps didn't make it clear that it was argument as opposed to a quote from Canada's position. And I thought that was unfair to Canada, so I wanted to correct it. It's my argument as to what I understand their case to be. So I am now, yeah.
Just be clear then, these errata sheets that were sent to me electronically are now incorporated in your compendium and I don't need them. Is that correct?
No, you need to go, I guess, manually.
No, but they're in the compendium. I don't need these separate documents. Right.
You want to, sorry.
Today have the corrections on the hard copy you have, those are handwritten corrections.
Yes.
So that they have the same, they say the same thing, just one has handwritten corrections, one has the typewritten corrections.
Right.
But the document itself, our main argument has not been corrected.
No, that's not.
I'm just
No,
asking if I can get rid of what you emailed me.
Yes.
Yes.
In the,
Yes.
Gotcha. Sorry.
Yeah.
and I will annotate these submissions myself
Perfect.
based on the errata. Thank you.
I've now reached the next part of my outline, which is an overview of the credibility, reliability, et cetera, of the witnesses. And I wonder if this would be a good time.
All right. So what is a reasonable amount of time for a lunch break for people who need to get something and get back here? Is it 2 o'clock? 2 o'clock, earlier than 2 o'clock? What is reasonable for you?
2 o'clock would be fine for us, or earlier if the court desires. We're at. I hear 1:45.
1:45, anybody else?
I hear 1:45 back here.
Going for it.
Yeah, we have 1:45.
All right. Maybe no longer than that. All right. So thank you. We'll break now. We'll resume at 1:45. Thank you all.
Thank you.
Well, you're all right.
Superior Court of Justice has stood down until 1:45.